Welcome back. I'm Ladan Korhani. I'm a family lawyer. So I want to talk about the stages of Children's Aid Society in court. So you've been served, or maybe you haven't even been served, but you've been told to attend court, and your children have been apprehended, or maybe the children are with grandparents or a friend right now, but not in your care. So what happens here? The first appearance court is usually you agree to some terms, giving you some parenting time, and usually the child or children stay with either the society in foster care or with another person that you may be okay with, but you may also not be okay with. Okay, so negotiations happen, but very limited usually, because you don't have any paperwork before the court, and most of the time you haven't even been served. So now here we go. Now you're served personally, either before court or after court, and you see an application along with an affidavit. The application is the pleading that starts the whole process in court. Once you're served, you attend first appearance, and then you attend what's called a case conference hearing. So this case conference hearing is similar to family court, except what you need to actually fill out and file is a little bit different. If you go online, ontariocourtforms.on.ca, you'll see that there's specific case conference briefs that need to be filed separate, different from family court. And then you go to a settlement conference, but sometimes it's not that simple where it goes from case conference to settlement conference. Most of the time, because you're in CAS court, you may have several case conference hearings before you have a settlement conference hearing. And the reason for that is they want to give you opportunity to do what they need for them to return the child to you. Sometimes they say that they need consent forms signed to get your medical reports. They will ask you to take some courses, to take some counseling. It's always different, so I'm just giving examples. Or if you have substance abuse issues, to make sure that you don't take drugs anymore, and they might need blood work, and so on and so forth. And that can take time. It's not always within a month or two or three. It can take a long time. So the stages are first appearance, case conference, several case conference usually, settlement conference, and then you go to what's called, if you haven't settled and you are not getting what you want, you go to a motion for summary judgment or a trial. So the motion for summary judgment is, the preparation for that is by way of an affidavit. It's a 14A. Again, you can get that at ontariocourtforms.on.ca. It's where the judge provides a final order. But in order for you to have a say, or in order for you to be able to make arguments at this motion for summary judgment, you're required to complete a 14A. You're also required to do a factum. A factum is legal arguments that are put on a piece of paper along with cases that you're relying on. It's usually a lawyer does that. It's not that easy to do. But in a lot of cases, the court, depending on the jurisdiction, will be okay with you not providing that factum. But I don't want to say don't provide it, because it is a requirement for a motion for summary judgment. Now, it can also go to a trial. So when does it go to a motion for summary judgment, and when does it go to a trial? The motion for summary judgment, if there are no credibility issues, or if there are no genuine issues for a trial, it goes to a motion for summary judgment. Trial, it says it's very complicated. There are some genuine issues that are required to be argued at a trial. That's when it goes to a trial. And essentially, you want a trial. You don't want it to be just a motion for summary judgment. So you're arguing at a motion for summary judgment, you're arguing that there are genuine issues for trial and that you do want a trial. And sometimes when you go to a motion for summary judgment, the court might agree with you and set the matter down for a trial. Now, CAS is one of those situations where, it has to do with your kids. And so does family court, but in this case, they have taken the kids from you. So you do want to see if you can hire a lawyer. If you're making too much money, you can't afford a lawyer, this is me telling you how this all works. But if you are on Ontario Works, on ODSP, or you're not working, or you're very low income, call legal aid. You can get a certificate. It's called a legal aid certificate. With this certificate, you can hire lawyers that are in private practice that will take on your matter. And you can get a list from legal aid of the lawyers in your jurisdiction, your community, that will accept legal aid. So definitely take those steps. How do I contact legal aid? Google legal aid. When you Google them, there's a phone number, and you let them know, my kids have been taken from me, this is a CAS matter, and they'll give you, they should be able to give you a full certificate if you qualify financially. All right, thank you very much. Until next time.